Good afternoon. My name is George Lemieux. I have the privilege of being the chairman of the board of the Gunster Law Firm. On behalf of myself, Bill Perry, our managing shareholder, our board of directors, all of our attorneys and team members, welcome to another one of our webinars on COVID-19. Today, we're going to focus on the uptick in litigation due to the COVID-19 and how to prepare your business for that litigation. Some housekeeping issues before we get started. We are recording this webinar. You can review a replay on demand from Gunster's COVID-19 website. It will be posted tomorrow morning. Feel free to share it with others. You can find additional timely information and resources there as well. You go to gunster.com/COVID-19. No hyphen between the COVID and the 19. That's gunster.com/COVID-19. If you'd like to ask a question, I encourage you to submit that question along the way. You'll see the Q&A feature on your screen. Questions will be sorted, read aloud. We won't state your name. They'll be anonymous, and we'll answer them the best we can by the most appropriate person on today's panel. We've also created a dedicated COVID-19 email inbox that we monitor regularly. So if you can't ask a question today or you think of a question later, you can send a question there. And that email address is covid19@gunster, GUNSTER.com. Additionally, contact information for each of the speakers is visible on your screen in the box where it says speakers bios. Today, we're going to talk about litigation and how litigation may arise because of COVID-19. As stores, restaurants, and workplaces begin to open, business owners and operators need to be aware of the increased likelihood of litigation resulting from the pandemic. Threats from employees, customers, vendors, and other sources will create an uptick in legal action. In fact, we're already seeing a number of cases filed, and those case filings increase every day. We're going to have a number of speakers who will speak to you today, and they'll talk to you about various topics concerning litigation. As a general overview, right now, Congress and the state legislature in Florida is talking about passing legislation that would provide some type of limited immunity for businesses for claims made under COVID-19. We're not sure what that legislation is going to be. We're not sure if it's going to pass, but it is being discussed. We spoke with Senator Marco Rubio on Gunster's A View from the Top. His view was that that legislation would provide some protection. It would provide protection against what are called negligence claims for breaching the standard of care, but would not provide protections for claims of gross negligence. So that might still leave a lot of opportunity for these lawsuits. No one should rely upon the fact that there's actually going to be legislation that provides immunity. If it does, that's great, but businesses need to be prepared as if that will not happen, because that is the current state of affairs. There is no immunity against these lawsuits for businesses. So let me introduce our first speaker. Joe Santoro is a shareholder in our West Palm Beach office. He is the chair of our Labor and Employment Practice Group. He is a litigator, and he serves as employment counsel to the Gunster Law Firm. He's going to speak about litigation defense against internal and external threats from employees and customers. Joe?
Thank you, George, and thank you everyone for joining us again for another webinar on these important topics. As George mentioned, we are already starting to see the lawsuits get filed, and while we anxiously await some legislation giving some employers some comfort that they have some immunity, it doesn't exist yet. So what I thought we would talk about today, and the way I've organized what I want to talk about, is just to give you kind of seven things that I think are the do's and don'ts that you need to be thinking about and doing in order to protect yourself and your company from litigation that might occur. And the first one, I'm not going to spend a lot of time on this because it was the subject of one of our prior webinars. The first one is, if you haven't already, do develop a return to work plan and a protocol for your company that is both measured in the things that you are going to do and consistent with the guidance that's available, not only the federal guidance, and but also guidance that might be specific to your industry. We talked about in our last webinar the fact that there are a lot of sources of federal guidance. There are, of course, the White House's guidance on reopening, OSHA's guidance on preparing workplaces for COVID-19, which came out in March, the Center for Disease Control's guidance, as well as its interim guidance for businesses and employers to plan and respond to the coronavirus. The EEOC has issued several different guidance on what employers can do in order to comply with the EEOC laws. And then not the least of which is your local, your state and local orders. In fact, Miami-Dade County came out with new guidance last Friday, and it's complicated. So you want to make sure that you have, if you haven't already, you've got a plan in place and a protocol in place to safely reopen your business. Why does this matter? Well, as George mentioned before, in the absence of some type of immunity, businesses are going to, and this guidance is going to be an indicator of what a company's standard of care is under a negligence claim for reopening their business. And so most likely what we're going to see is that the various guidance that's out there is going to be used to determine what the standard of care and how a company should have operated in order to protect not only their employees, but also business invitees and guests. And I guess if there is a little bit of good news here is, and most of you may already know this, that for purposes of your workers, we do have workers' compensation immunity in Florida if you have workers' compensation insurance. And for the most part, if you have an employee that gets sick at work, your company is going to be covered by that immunity, meaning they can't sue you outside of the workers' comp system for injuries that occurred at work, including if they are able to establish that they got infected at work. But there are exceptions to that immunity. And one of the exceptions is if an employer commits what amounts to an intentional tort, meaning that the employer was aware of a dangerous circumstance on its premises and that was virtually certain to cause injury or death to an employee, and the employee was unaware of that circumstance and was unable to make an informed decision about whether to come to work and accept that risk. So one of the things that you want to make sure you're doing is have this guidance in place and also train your employees on your protocol to make sure that they are informed not only about the risks that are out there, but what the company is doing to protect them. But that immunity does not apply to anyone else that might come onto your premises, such as your guests, vendors, other types of business invitees that come onto your property. You have no immunity for claims by them if they get infected coming onto your property. And so for that circumstance, in the absence of some legislative immunity, you're going to have general negligence standards that are going to apply. And if they're able to establish that you did not comply with the standard of care, and as a result of that, they got sick. Now, that's not necessarily the easiest thing to show that they got sick on your premises, but if they're able to establish those things, then you could have a claim. And so, one of the important things is, and this leads to the second do on my list, which is actually do whatever it is you say you are going to do in your protocol. Now, when we talked about the protocol last time, what I told you is that the guidance is just guidance. It's not law. It is a series of recommendations by the agencies. And for the most part, you're able to go through that guidance and determine what works for your company and what things you should do. But if you adopt a protocol because it seems to work for your business, you need to follow it. Because we might be able to argue in a negligence claim that maybe you didn't have to do temperature testing, or maybe you didn't have to provide masks to your workers. But if you elect to do that as part of your protocol, it's going to be very hard for us to argue that that's not reasonable and part of what your duty of care was in operating your business. So the most important thing that you need to do is, once you adopt these things, you must make sure that you're following the things that you have already established as part of your protocol, because if you don't, then it's going to be very difficult to argue that it was not within the standard of care. So my next do not reject work from home requests without fully understanding the employee's circumstances. So those of you that have looked at the guidance have seen that most of the guidance suggests that for individuals who are vulnerable individuals, you should consider providing accommodations to them certainly during the early stages of your return to work, including working from home, if that is available. Well, that's not required, but the thing that you have to understand is that all of those things that make someone a vulnerable individual are likely going to be disabilities under the Americans with Disabilities Act, as well as Florida's Civil Rights Act. So if someone has a respiratory issue or has an immunodeficiency or has some other, they're being treated for cancer, or has some other condition that makes them a vulnerable individual, they are probably considered disabled under the Americans with Disabilities Act, and therefore you might actually have a legal obligation to provide an accommodation to that person, including potentially working from home. So what you have to make sure you do is understand when you have someone that makes a request to work from home and they tell you that they are a vulnerable individual, it's important for you to fully understand the circumstances why that person is making that request, so you can determine whether or not you might have a legal obligation under the Americans with Disabilities Act to accommodate them by working from home. And I will say this, for years, we held on to, as employers, this idea that most jobs can't be done from home. Well, I would suggest to you that we now know that most jobs can be done from home. And so I think it will become much harder to deny an employee as a reasonable accommodation a work from home request unless that employee is truly unable to do the essential functions of the job from home. So be very careful and make sure you do not reject out of hand an employee's request for a work from home accommodation. The fourth do I have on my list is more of a trial lawyer's view of things, which is do treat employees that are scared to return to work with what I like to call a soft hand. Okay, and just so we're all clear, an employee being afraid to work in the office and having fear is not something that you have a legal obligation to accommodate it. However, it could be very easily for them to turn that fear into perhaps an objection to how the workplace is being run, potentially arguing that the workplace is not being run safely and in violation of OSHA's requirements. And then all of a sudden your termination of that employee because they wouldn't come to work because they were afraid becomes a claim, a whistleblower claim that they were refusing to come to work because you weren't complying with the law. So I want to make sure that you guys understand that from a trial lawyer's perspective, you are much better off going through a process with that employee as opposed to outright terminating them because they are afraid to come back to work. And that process should simply be, number one, trying to educate them about what you're doing to keep them safe. Number two, give them an opportunity to reconsider their position and be thoughtful in communicating with them about it. And then finally, not firing them, but giving them the opportunity to come back. And if they don't come back, you would call it a job abandonment as opposed to an affirmative termination. I would suggest to you that in the eyes of a jury, that is going to be much more palatable rather than saying, hey, if you're afraid to come to work, you're fired. Because jurors are people too, and you're going to have jurors that for sure will feel the same way and have the same fears. The next thing, and I want to be really brief about this, is do make sure that if you have people working from home, you are compensating them correctly. For exempt employees, it's easy. But for hourly employees, you want to make sure that you have some sort of writing in place with them to tell them when they're going to work and what their hours are and have an agreement in place so that there's no ambiguity about how much time they're spending at work on work activities, and there's no ambiguity about the fact that you're paying them for the time that they're working from home. The same holds true with other things that you might have changed. For example, if you have shut down your common spaces in your lunchrooms and you have employees working at your desk, please make sure that there's clarity that those people are not working, that they're eating lunch, and that they have time free to eat lunch so that you don't run into a wage and hour claim. One additional do is do consider whether you want to have an exculpatory clause and whether that's appropriate for your business, and do not pull one of those off of the internet. What am I talking about? You probably heard people saying, well, I'm going to have my guests sign a release when they come in. And that is something that can be done under Florida law, but it is incredibly complicated to get it right. And because you're talking about releasing future liability, the courts are they're going to be very hesitant to enforce a release like that. It's kind of against public policy to release future negligence. And in order to be able to have that be enforceable, it has to be written correctly, and it has to provide sufficient notice to the person of what claims they're waiving, and it has to be very clear and written in a way that complies with the law. So if you're going to do that, make sure you talk to your lawyers. Don't pull a form off the internet because it likely won't work. And then my last do is do check your insurance policies. Many of you have not even thought about this yet, but a lot of insurance policies, including ISO form policies, have exclusions for losses that result due to virus or bacterial infections in the workplace. I think it would be very important if I was running a business to reach out to your insurance broker or carrier and have a good understanding of what you're covered for and what you're not covered for, because it may make you make different decisions, including different decisions about when to reopen your workplace if there's still significant risk. So those are my 7 do's and don't do's. Certainly happy to answer any questions at the end.
Thank you, Joe. Appreciate that great oversight. I want to turn it next to my colleague, Mike Marcel. Mike is a shareholder in the Fort Lauderdale office. He's in the business litigation section. He's an experienced litigator and trial lawyer, and he's a former chair of our business litigation practice group. Mike's going to speak today about business divorce, how to be prepared for business disputes, and which statutes may be relevant for dissolving businesses. And the reason why we bring up this topic is that oftentimes when there's economic stress, businesses that were going well between, say, members of an LLC or partners, things aren't going so well now, and a dispute arises between those folks, and there's a business divorce. So that's what Mike's going to talk about today. Mike?
Thank you, George, and you're exactly right. And it's very much like a marriage. When times are good and money's good, marriages are often successful, but when money gets tight, marriages go bad, and businesses are no different. When the profits are high and the times are good, like the last 10 years, you don't see a lot of business dissolution actions. You see some, but not like you do when times are bad and money's tight. Just thinking about in the context of current times, if you have a restaurant, there might be a dispute between the partners or shareholders of a corporation that owns a restaurant as to whether or not you want to remain open, whether or not you want to take stimulus money, whether or not you want to go in a different direction. So that can cause a lot of tension, and surely there's a lot of tension out there right now because of the current situation. So what do you do in these situations when you have this kind of dispute that may lead to what we call a business divorce or business dissolution? The first thing you always do, and regardless of your corporation or limited liability company or partnership, you want to read your own manual. And your own manual is typically your shareholder agreement, your partnership agreement, your limited liability company membership agreement, and that will usually tell you what to do when times are bad. Oftentimes, if you want to divorce in a business, there'll be a provision called a deadlock sale provision in the agreement that will give you a roadmap of exactly what to do in that situation if one member wants to buy out another member or a shareholder wants to buy out another shareholder. But for a lot of mid-sized and small businesses, the manual is not so thick. It's not as well planned as a major corporation. So we find that oftentimes a shareholder agreement or a membership agreement will not have a deadlock sale provision or some roadmap for what to do when there's that type of dispute. And for those situations, Florida provides a couple statutes for it. The general statute for corporations are set forth in Chapter 607 of the Florida statute, and for limited liability companies, it's in 605, Chapter 605 of the statutes. And I want to focus on those two, even though there's a lot of different business entities, because A, there's only so little time in this webinar, but B, these are the most common types of business entities we see in Florida that have these types of disputes. So I'm going to focus on mid-sized corporations, subchapter S corporations, and limited liability companies. Know that if there's nothing in your shareholder or membership agreement, there's two ways you can dissolve. Just like there's two ways you can divorce. You can do it the easy way or the hard way. The easy way is the non-contested divorce. The hard way is the contested divorce. In Florida, like most other states, the non-contested business divorce is statutory. The statute will say if you have a majority of shareholders vote in favor of dissolution, unless the agreement provides otherwise, you can dissolve, and it's a quick and easy process. Same thing for LLCs. The problem is when you have a true deadlock. If there's only two shareholders or two members, to give you the easiest example, one wants to keep the business going, one wants to close up shop, what do you do in that situation? Well, then you have a contested business divorce, and what you need in that situation is a judicial dissolution. Just like in a regular divorce where you have to go into court, get the judge to bless the dissolution of the marriage. Same thing for a business. You got to get the judge involved, and you have to make certain showings to persuade a judge that dissolution is proper when the other member or the other shareholder is opposing it. And the standard, either under an LLC or a corporation, is fairly straightforward. You have to show a deadlock. On a corporation, the directors are deadlocked and the shareholders can't break that deadlock. And that deadlock causes some kind of irreparable injury to the company, or the affairs of the company can no longer be conducted to the advantage of the shareholders. It's not a high test, but it is a test that you have to meet. And the test is substantially the same whether it's a corporation or a limited liability company. Now, there are alternatives within judicial dissolution that the courts and the legislature have enacted or employed. And both are the two I'm going to talk about are useful, but they're also traps for the unwary. First, when you file a dissolution action, if you're a member of an LLC, you file a judicial dissolution action, the other member is opposing you. By filing that dissolution action, you are putting your shares up for sale, or your membership interests up for sale. Essentially, if the other member, the defendant member in the lawsuit, elects to purchase your membership interest or your shares, they can do so. They now have a statutory right to do so. And there will be a court hearing, an evidentiary hearing, to decide what the value of your ownership interest is in the company. And then the judge, after an evidentiary hearing, will order the defendant to purchase the plaintiff member's shares or membership interest for the price that's determined by the court. So two traps for the unwary there. Note that by filing the dissolution action, you better be sure that you want to sell your ownership interest in the company. For those litigants who use that filing a dissolution action as mere leverage and trying to work it out later in a mediation or some sort of dispute resolution process, you might not have the opportunity to do that because you've now put your ownership interest up for sale. The second problem with that is from the defendant's point of view, when you elect to purchase, it's not a negotiated price anymore, or not the price you would want to pay for those shares or that membership interest. The court determines what that price is based on expert testimony that's oftentimes conflicting. So 2 traps for the inquiry on that in terms of filing a judicial dissolution. The other problem and challenge that comes up with a judicial dissolution is a judge may appoint a receiver for the company once the dissolution is filed in court. A receiver then takes control of the company, and the board of directors or the managers or members of an LLC are no longer in control of the operation of the business. In the corporate statute, judges oftentimes will even appoint what's called a provisional director, which is if there's a deadlock, say one shareholder voting one way, one shareholder voting the other way, and they're both directors of the company, then the court may provide an independent provisional director to break ties in the operation of the company. Problem there being, of course, is you also are no longer in control. It's really the provisional director, like the receiver, that will have control of the company. So the keys to summarize are: read the manual, read what your agreement states, be careful when you file a judicial dissolution action because there may be some unintended consequences that you did not think through. And third, and most importantly, is just like in a regular marital divorce, in a business divorce, it's best to contact a litigator experienced with the process to guide you through the nuances. Because as much as I've tried to simplify these statutes, there's a lot of nuances, exceptions, defenses that may apply depending on your situation. I'll be available to answer questions later, and thank you, George, for the opportunity.
Thank you, Mike. Great job. Next, I want to turn it over to Jonathan Osborne. Jonathan's also a shareholder in Gunster's Fort Lauderdale office. He also practices in business litigation. But in addition to business litigation, he's involved in white-collar criminal defense as well as internal investigations. Jonathan is a former assistant United States attorney in the Southern District of Florida. Jonathan is going to speak to how to protect your company against internal and external fraud and how the government may handle enforcement actions. This becomes really important during times of economic stress. We saw during the Great Recession not only Ponzi schemes from Madoff and Rothstein and others, but we saw lots of cases being filed where internal people inside of companies were accused of stealing money from the company. We're already seeing those cases filed now here in the last couple of weeks. So Jonathan will walk you through both how to protect yourself from internal and external threats. Jonathan?
Sure, and good afternoon, and thank you for the introduction. George, your introduction really hit the nail on the head. And so now that Mike has talked about the first preferred topic of businesses, and that's divorce, I'll talk about the second favorite topic, which is what happens when an employee steals or commits fraud against a business, or in the alternative, how to protect yourself against threats from external fraud. So starting with the topic of internal concerns of either theft or fraud, it's important at the outset to understand the triggers and the risk factors that can lead to internal theft or employee theft. And it's really important in the context of the pandemic to recognize that we are in unprecedented territory, both as businesses and as individuals. And there are always two components of every fraud, especially from an insider. The first is need. The second component is opportunity. COVID-19 has presented very unusual challenges with respect to need. Many businesses have shuttered or slowed, and thousands of people around the country are out of work, were furloughed, or even if they are working, are concerned that they could lose their job at any time. As it relates to opportunity, COVID-19 has also presented unique challenges. With so many workers working from home, it's that much harder for businesses to maintain both their internal controls as well as their oversight over the day-to-day activities of their employees. And in any business, in particular the types of businesses that Gunster represents routinely, the importance of having first round and second round checks with any financial transaction, in particular virtual transactions, is at an all-time high. The opportunities for employees working from home, or even once we return to the office, to have a lapse in judgment are higher than ever. And thus it's important to talk about ways to prevent these types of things from happening, and then also how to respond when you're dealing with this type of incident. So first, as it relates to internal controls, it's important in any business to have a separation of power and a separation of duties. And here, this is, in particular, when it comes to the finances of the business, making sure that the person who approves the invoice is not the same person who pays the invoice. And if it is the same person, to make sure there's at least one other level of review for the money going in and out of your business. It's also important to have written policies and procedures and consistent training across the board for employees that are working from home, as well as those that are within the office. It's important to go back and check all of your documentation requirements and to ensure, as Joe mentioned earlier during his presentation, that those documentation requirements are being followed. And lastly, it's more important now than ever that your company invest in adequate data security that is relevant to the market sector in which you operate. So having talked at a very general level about the threats that can come from inside, I do want to talk briefly about an emerging threat that many businesses around the country and around Florida are facing externally. And it's referred to in the law enforcement community as business email compromise fraud, but it also is often referred to as CEO fraud. And so we've all read news accounts of an example, and I'll just use a simple example of an executive assistant receiving an email on a Monday morning from the CEO or the CFO of a company directing her to transfer money to an account or to pay an invoice, only to find out later that day when she speaks with the CEO that she or he never authorized or requested that a wire transfer be sent. So basically, the premise of this fraud is that a hacker or a fraudster outside the business has either duplicated a email account that sounds like the CEO's email account, or they've hacked the CEO altogether. And in that instance, it is very, very difficult, if not impossible, to get that money returned to the business. And with these types of frauds, as well as frauds involving false invoices and data theft, it is key that you have in place internal controls, internal protocols that will protect your business against these external threats. One suggestion that the FBI makes and that we also make is that for any wire transfer outside your business, that you require the person sending the wire to have an actual telephonic, or in the instance of COVID-19, a video conference discussion where it is confirmed that the person who sent the wire information is the person that is actually the representative of the business that you intend to make a transaction with. And lastly, so I want to focus for my last point on internal threats. In the event of a suspected theft or suspected fraud by an employee, I think the first reaction and the first inclination and temptation will be to immediately fire that employee. But we recommend that you at least consider suspending the employee while you're able to conduct an investigation. The investigation is really the best way that your business is going to, one, learn what happened in this instance, two, hear the employee's side of the story and understand what their needs were and understand what opportunity your business practices provided for them to make this bad decision. And lastly, what we learned through internal investigations is that once the employee is gone, it's almost impossible to get them back for an interview. And so with in mind that you have a responsibility to the shareholders of your company, as well as to the other employees, to do a thorough investigation when you have an incident like this, it is key to exercise deliberation. If you have the internal capacity to do a thorough and independent investigation, then that is a good idea. But if you do not, we recommend that you hire independent external counsel that can walk through the facts, determine the facts of what happened before, and then give you advice going forward about how to prevent these types of incidents from occurring in the future. And then lastly, just to talk about government intervention. As it relates to all the various types of relief that's been made available through this pandemic, and so that relates to the PPP loan applications, and as well as the forgiveness of those loans, and at the state level as it relates to things like price gouging and other areas where the Attorney General has supervisory authority. We expect that the government enforcement actions will take the form of various things, including audits, investigatory subpoenas, as well as knock-in talks, when the government will actually come to your business and initiate a voluntary discussion with your employees about how they're complying with the rules that govern your business. And so those are some of the threats that businesses in COVID-19 are facing internally, externally, and from the government. And I'm happy to provide any further detail that would be helpful.
Thank you, Jonathan. Next, we're going to turn it to Tracy Rollins. It seems like we're going through a parade of horribles here: business, divorce, and fraud. And next, we're going to talk about bankruptcy. Tracy Collins is a shareholder in our business litigation section in the West Palm Beach office. She focuses on creditors' rights, bankruptcy, and commercial litigation and government investigations. And she's going to speak about creditors' rights, practical information for companies who may be dealing with solvency issues, and strategies for dealing with vendors and contractors who may be distressed. Tracy?
Thank you. Thank you, George, and hello to everyone. I think that maybe I can be a little more positive or a little less frightening than some of the things we've been talking about, because the point I want to make to you is that there are things you can do now if you are worried about. So I'm speaking to you as a landlord, as a creditor, as a bank, or even just as a counterparty to a contract. When you're worried about the other side's performance and their potential impending insolvency, not necessarily bankruptcy, but just economic distress. And the point is that there are things you can do. Don't wait for that other party to formally default or file bankruptcy. There are things you should be looking at and doing. Just put together somewhat of a laundry list of such things, and I'd like to run through them with you, with apologies for just ticking them off. But I think that some, perhaps many of these, will be actions that you can take right now to protect yourself, your company, your business. First is your material contracts. Go through them. Review them for termination rights, for force majeure clauses, for insurance provisions. If termination of that contract is something you want, it should be pursued now, before that counterparty's bankruptcy. If you're an inventory supplier to a distressed distributor, consider turning off that faucet, particularly with increasing accounts receivable. For yourself, be mindful of potential technical contract or loan defaults under, for example, liquidity ratios or other breached covenants, and make sure that you address those defaults even if the counterparty is quiet. We tend to think as long as no one's saying anything, we're okay and can fly under the radar. But if bankruptcy is a prospect for the party on the other side, you want to take care of these things now. Prepare for that insolvency, potential insolvency by your co-guarantor, your partner, your shareholder, the member of your LLC, and how that might affect your company, your partnership, and its contract obligations. If both sides to the contract have breached, you and the counterparty, should you file a lawsuit first? How about contract amendments, tolling agreements, forbearance arrangements? There are lots of things you can do short of filing a lawsuit. Injunctive relief, is that something that you need for bad behavior that you should be pursuing? Are there any contract payment netting provisions or offset rights available? These are quite frequently overlooked, but really very helpful, especially at times like this. Exercise or reject outstanding rights of refusal, stock options, other equity interest options. Make sure you pay attention to those and land at least one way or the other. How about a heads up for counterparty intercompany dividends and asset transfers? Be very mindful of these. Fraudulent transfers are going to be at an all-time high when people and entities are desperate. And if you're relying on an ipso facto, that's a clause that might say a default is triggered by the filing of a bankruptcy, or a waiver of rights in a subsequently filed bankruptcy, or maybe it provides for a pre-petition waiver of the automatic stay. Those provisions often exist in contracts, but aren't always enforceable. We put them in there thinking it's worth a shot, but make sure you understand the likelihood of being able to enforce those, particularly if you're relying on them for actions you're taking at present. you can do to improve their enforceability, perhaps offering new consideration, a forbearance agreement, a tolling agreement, something like that, that might breathe life into them. Think about disclosure obligations that you might have on behalf of your company regarding a particular counterparty or a shareholder or a guarantor and their pending insolvency. Has anything been triggered that would require that disclosure? You demand more collateral, additional collateral, substitute collateral, performance assurances, or even assert a contractual lien. Confirm that your security interests are perfected. This is the time to check on your UCC statements and your security instruments. Make sure that your credit support's in place and potentially take possession of the collateral if you can. Don't wait until there's a formal default declared. How about lockboxes? Are they being swept properly and as frequently as is possible? Are you holding expired letters of credit? I hasten to say I've seen this many times. Opportunities perhaps for repricing or rescheduling payments. Address concerns about preferential or fraudulent transfers. This is something that business people aren't always familiar with, but a creditor's rights lawyer can really advise you as to whether that exists, whether you're about to step into such a fraudulent transfer, and how to avoid it. And plan for your shareholder, member, or partner's bankruptcy and its impact under the shareholder agreement, the operating agreement, or the partnership agreement. Will this be an event of dissociation? And if so, plan for that. Make sure that you as the surviving party know what your rights are, how to implement buybacks, any other rights that might be triggered. So it's unlikely that all of these apply to you. If they all do, you need to call us right away. But most likely one or two, hopefully, cause you to think about things you should be doing and actions you can be taking now before you find yourself in a very difficult position. So I hope that's of help to you in protecting your rights in the future. Thank you.
Thank you so much, Tracy. It's now my privilege to introduce to you Laura Guitar. Laura is an executive vice president and partner at RBB Communications. She leads the agency's crisis communications and issues management division. I've had the privilege of working with Laura specifically on some matters. She does fantastic work. Today, she's going to talk about corporate communications and crisis communications, guidance that you need as you prepare for and manage potential litigation. Laura?
Thank you, George. I'm going to talk about communications as it relates to potentially all of the situations that have been discussed to this point. And there are a number of reasons to consider communication strategies at the outset of litigation or a lawsuit. And the first reason is that, quite simply, the court of public opinion holds sway. Now, this is not to suggest that we think litigation should be tried in the media. That's almost never a good idea. But it is important at the outset of an issue to consider the possibility that it may become public and to start to plan and put strategies around what you might do in that instance and how you might communicate with key stakeholders. What we know is that information shared in one forum can have impact in another forum. And so it's very important that communication strategies align very closely with legal strategies and that the legal strategies take precedence while everyone is focused on the organization's long-term reputation moving forward. A capable crisis communications professional, and particularly one with litigation experience, will know how to work with legal teams in order to help support the legal strategy rather than to distract from it, while also protecting the client involved. So there are a number of things you can do before a lawsuit even occurs to help protect yourself should one arise. The first is to ensure that your crisis plan addresses legal action as one of the scenarios that you're considering. And this is more than just thinking about who might be involved in managing the lawsuit through the process. It also addresses issues like, what if it becomes front page news? What if it turns out we have an employee leak? These are important things to think about ahead of time because putting plans and strategies in place in the moment is never a successful approach. It's also important to refresh our media and social media policies for employees. Very often employees sign these when they join an organization as part of the onboarding process and they never see them again. And we believe they should be disseminated on a regular basis, twice a year, 4 times a year, to ensure everyone is consistently made aware of what expectations are in terms of their engagement with media and on social media. It's also important to have an existing earned media, public relations media program in place. There's lots of reasons to do PR in general, but one of the ways that PR supports crisis communications is it builds a bank of goodwill that you can draw upon when you need it in times of crisis or when a lawsuit's in play. At the point a lawsuit becomes public, it's far too late to explain to a reporter who you are and how a company's doing business. Companies need to build that equity before something happens. It's not to say the reporter will pull punches, but they may give a benefit of the doubt when it's helpful. And then finally, something that should be done before legal action is ever on the table is making sure disgruntled employees have a place to go to express their concerns. Time and again, we've seen disgruntled employees cause more problems in legal cases than is necessary. If disgruntled employees have a place to go where they feel like they're heard, they feel like they can have some dialogue, even if their issues aren't addressed or aren't resolved, it tends to take some of the heat out of how they're feeling about things and may stop them from going directly to the media rather than discussing things internally. So those are some things you can do on the front end. But what happens when you wake up and the legal action is on the front page of the paper, or NBC has called for commentary for its 6:30 nightly news? At this point, it's important to note that there are 2 communication tracks. Previously, there was the communication track associated with what was happening with the lawsuit in the court system and as it wound its way through the legal system. A second communication track is now introduced, and that's what's happening with the company and the market as the result of the lawsuit becoming public. So these are different areas of focus, but as previously mentioned, one forum impacts another. So it's critical at this point that whoever's leading communication is in regular discussions with legal counsel and able to work at the direction of legal counsel. Very often the litigation team is going to want to limit communications about the case. And that's an important thing for a communications person to be able to understand and support. And it's also an appropriate step for a private company. We've probably written 10,000 versions of statements that say something to the effect that, we do not comment on pending or active litigation. And that's completely appropriate in most circumstances. For companies that aren't private, however, so for companies that, let's say, exist to serve the public good, universities, churches, charities, higher education, that option isn't always as clearly available, and that may take some additional nuanced communication around active lawsuits. One of the most important things once a legal action becomes public is to slow the roll. Very often media will try and accelerate the pace and set the timeline for how dialogue is going to occur. And we should never allow clients or companies to accept the media's timeline as their own. It's perfectly acceptable to tell a reporter who's pushing for a very fast response that we're just not going to meet the deadline. That the issues are complicated, we want to make sure we get things right, and we'll get back to them when we can. A lot of times reporters will create false deadlines and say things like, well, if I don't have your response, I'm going to go ahead with the story on the 6:30 news anyway. More times than not, I've seen those stories not run. It's a way to get companies to jump and respond, but very often those stories never come to light because the reaction from the legal team or the company is critical to putting the story together. So it's never a bad thing to take a step back and slow the pace of what's being made public and how it's being shared. It's also critical to institute media and social media monitoring. Many agencies have these tools, many in-house teams have these tools, but even if you're not responding to media in the moment or responding to social media conversation, it's absolutely critical to know what's out there. Those are data points that can help guide strategy as to what you might do down the line, because they can show you trending data. So you can look and see how the conversation's evolving. You can see whether media coverage is gaining or losing traction, whether it's starting to enter top-tier media or whether it's remaining at a lower level. And all of those data points should be factored into any communication strategy. It's not enough in our data-driven world to just put our finger up and pick a direction. We really need to take as much data as we can glean into consideration. And so the other piece of communications that we find ourselves doing a lot is helping clients and companies stay focused on their business. While for litigators and attorneys, lawsuits and the process of litigation is a day-to-day business and not a big deal, for most executives, it's not something that they deal with or want to deal with on a regular basis. And very often emotions are high. We've seen a great amount of anger and frustration when executives feel like lawsuits have been brought frivolously. There can be some sadness. There can be a lot of emotions that impact rational thinking. So very often our role is to help calm the emotions and remind people of the long-term strategy. You know, we've had a lot of CEOs who want to try cases on the front page of the paper because they feel like the case has so little merit. But it's important for us to help them stay focused on both the legal strategy and the long-term communication strategy. And so the last thing I'll say is that it's important in today's world to understand the media landscape. The way that the media makes money now is through advertising on its website to a very large degree. And the way that the advertisers value the websites are by the number of clicks and the number of views that the stories get. And so many reporters are compensated, at least to some degree, for the number of clicks that they get on stories. And study after study has shown that negative headlines get more clicks than positive headlines. So in a very literal sense, the media is incentivized to publish negative headlines and negative leaning stories. So gone are the days where we could have counted on a reporter to really dig in, understand the story, do their homework, and get the nuance right. That just doesn't happen in today's world. They're going for the fast hit and the fast headline. So it's important that communications is involved to help manage that process with the media, to help understand it, and to help navigate a safe path through that process.
Thank you, Laura. That's a really great presentation, and I think it's really helpful to everybody who's watching today. We've got some time for a few questions. As always, Joe is the most popular person at the dance and gets lots of questions. So let's start with that. One thing, Joe, that we had a request is if you would repeat what you said about information regarding insurance and exclusions for viral and other infections.
Sure. You know, the reason why I brought this subject up is because most people have business insurance for, you know, events and circumstances that happen in their facility or in their building. There are a number of policies, including the form, it's called a Form ISO policy, that many of you guys might have this for under your insurance. And that policy, that form policy, has an exclusion for losses due to virus or bacterial infections. And this is what the one I'm looking at says. It says we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. So what I was saying to you was, if you have a policy like that, then it makes compliance with all of the other things we talked about even more important, because you may not have coverage if someone sues your company because they got sick coming into your workplace. Now, not to be too negative about it, but understand that it is a tough thing to prove, right? You might get sued with someone saying, hey, I came into your facility, it's the only place I've been in the last 3 weeks, and I got sick. It's still difficult for that person to prove that they got infected at your location, but you might get a claim like that. And if you're not complying with your own protocol, then that would be a very attractive claim for, I think, a plaintiff's lawyer that wanted to bring it, because you can almost make like a negligence per se argument where you said these are the things that need to be done and you didn't do them. So check your policies and see if you have those exclusions, and you might even consider delaying your opening. I mean, if you don't have coverage, it may be the right decision not to reopen so quickly, because the risk might be higher than if you had coverage.
Joe, we also had a question on how to handle a situation where an employee asks to work from home because They want to have a reduced risk of contracting the virus due to the fact that their spouse is at a high risk or may fall under the definition of disabled under the ADA. What is the appropriate guidance for an employer who's dealing with a request from an employee under that type of situation?
So this is a very tough question, and it's a question that I've gotten many times over the past week from different clients. Here's the legal answer. The legal answer is that you only have duties to your employees, right? And if you have an employee that's a vulnerable individual, and you, even if they're not disabled, although we talked earlier about the fact they might also be considered disabled where an accommodation might be something you have to do, but your only duties are to the people that work for you. Those duties do not extend to their spouses or people that live with them. And, I think that you can probably identify, if you're a small enough employer, you know who those high-risk people are, and it's a finite group of people. But if you start allowing those accommodations for people that are concerned about people that live with them, where do you draw that line? And so I think that, you have to be very careful not to create a policy and a protocol where you're going to start considering the fact that, Sam Smith lives with his, 80-year-old mother. And so because he lives with his 80-year-old mother, you're going to allow him to work from home. Well, I think you might have a lot more of those circumstances than you might anticipate. So the opportunity for abuse is high. The opportunity for opening a Pandora's box of accommodations that you're not legally required to do is high, and it might get out of control for you. So what I've been telling clients is be careful. It's certainly nothing wrong with doing that. If you want to do it, you can, but it may be a much bigger group of requests for accommodations than you might be expecting. The only exception to that is under the FMLA, remember that an employee can have time off to care for a family member as defined under the FMLA that is sick. So if they're living with someone that they care for that qualifies under the FMLA, you might have to give an employee the accommodation under the FMLA of time off, but that doesn't necessarily mean work from home. So just be careful about going too far with I hate to say it that way, but going too far with your efforts to try to be helpful, because they could end up biting you.
Thanks so much, Joe. That's all the time that we have for today's webinar. I want to thank everybody who participated. I want to thank Tracy, Jonathan, Joe, Laura, and Mike for their presentations today. Remember that if there are additional questions that you have, you can send those questions to us directly at COVID-19@gunster.com. You can watch this video. It'll be available tomorrow morning by going to our website, gunster.com/COVID-19. And there's also additional information that might be helpful to you in your business, including other webinars that we've put on that you might want to view or share with others. Thank you so much on behalf of the Gunster Law Firm. Good day.